We know the work product doctrine protects attorneys' work product from discovery, but does it protect anyone else's materials that were prepared in anticipation of litigation? The 2013 case of Republic of Ecuador versus Hinchee explores this question in the context of an expert witness. After Chevron acquired Texaco Oil, several Ecuadorian class action plaintiffs sued Chevron in Ecuador for Texaco's pollution of the Amazon rainforest. The Ecuadorians, who asserted health problems and public and private property damage, were awarded over $9 billion in damages. With respect to and during this litigation, Chevron moved for arbitration against Ecuador in The Hague for allegedly violating a bilateral treaty between the U.S. and Ecuador. To bolster their respective positions in this treaty arbitration, both parties requested discovery from the other's expert witnesses from the pending litigation. Ecuador sought discovery in district court from Dr. Robert Hinchee, a Florida resident and Chevron expert. Ecuador requested a subpoena for Hinchee's document production and deposition. Chevron intervened and challenged the subpoena, which the court nevertheless issued. In response, Hinchee and Chevron produced about 94,000 pages and asserted that a remaining 1,200 documents were subject to work product protection. Ecuador challenged the work product assertion and moved to compel production of these remaining documents, requesting the court conduct an in-camera review of them. The court granted the motion in part, ordering Chevron to provide 40 of the remaining documents for in-camera review. Upon review, the court found that only one of the documents was privileged and 39 were either Hinchee's notes or communications between Hinchee and others. Some of these others were fellow experts, none were attorneys or attorney staff members. As a result, the court ordered Chevron to produce the 39 documents, stating that expert notes and communications amongst testifying experts weren't protected by the work product doctrine. The court also compelled production of the remaining documents that weren't communications or draft reports between Hinchee or his staff, and attorneys or their staff. The court further ordered Hinchee and Chevron to submit to the court for review any of the remaining documents for which they sought to bar discovery. Hinchee and Chevron appealed to the 11th Circuit.